Good morning, everybody. It's Mike Kennedy, Vermont Bar Council, with the second episode ever of Morning Grounds. Morning Grounds is a new feature, video feature, where I'm going to do short, quick hitters on interesting ethical topics of the day, I guess. So today I'm going to talk about the Avianca case. Avianca case is one many of you have heard about or read about over the past couple of weeks. It's the case in which the lawyer used artificial intelligence to research and draft a response to a motion to dismiss, looks at the product, asks the artificial intelligence tool, "Hey tool, do these cases that you cited, are they real?" The tool replies, "Yes, they're real." The lawyer doesn't cite check, files the responsive pleading as is, later learns from both opposing counsel and the court that in fact the cases did not exist, do not exist, and were completely fabricated by the artificial intelligence tool. Now, a lot of people sent me this article, more people than have sent me the story, more people than have sent any other story since I've been bar counsel, and that's great. Obviously, it's something that interests people, that also impacts professional responsibility and legal ethics, so I have no problem sharing my thoughts. Today, though, my thoughts might be different than some, not everybody, but than some of the thoughts of the people who sent me the story. And I'll just give you my takeaway. It's this story should be used as a lesson as to how the duty of competence, particularly the duty of tech competence, applies to lawyers. It should not be used to lead you to not use artificial intelligence in your law practice if it works for you, or not to explore whether artificial intelligence might work for you. Meaning, I am not here to say, nor will I say, that the use of artificial intelligence in law practice is a per se violation of the rules of professional conduct. What I'm here to say is that artificial intelligence is a tool that's available to lawyers, and a tool that has both risks and benefits. Okay, so stepping back for 1 second, the real sexy aspect of the story has nothing to do with the duty of competence, right? It has to do with the rule that prohibits knowingly making a false statement of law to a court. Vermont, it's in Rule 3.3. And people are like, "Oh, look, wow, artificial intelligence made false statement of law to the court. Terrible, terrible." It is bad. But let's not pretend that this problem didn't exist before. It took me 2 seconds of research to find a case in which a lawyer was sanctioned for making a false statement of law to a court. I think if I had gone beyond the 2 seconds, I would have found other examples of when lawyers were sanctioned for making false statements of law to a court. This is not something new that technology is causing. It's a problem that has existed and will continue to exist as long as humans are involved in the practice of law. Just had to get that out of the way. Okay, so the duty of competence in Vermont, Rule 1.1, requires lawyers to provide competent representation to their clients. There's a comment to that rule that makes clear that the duty of competence includes understanding the risks and benefits of relevant technology. And that's what artificial intelligence is, right? It's relevant technology that has both risks and benefits. And if anything, from the Avianca case, take this, that, hey, one of the risks of using artificial intelligence to do my legal research is I might get false, fabricated results. So benefits and risks of artificial intelligence. Are there benefits? Yes. I've mentioned some. You can go online and find hundreds, thousands of articles by people who know much more than I about lots of things, but specifically about how implementing artificial intelligence into your law practice might benefit both you and your clients. I did mention on my own a couple of months ago in a blog post, hey, here's an example of where it's pretty good. And what I'd done was I'd used ChatGPT and I'd typed in 3 of the more common questions that I get as bar counsel. The first 2 were 1, Mike, I represented a couple during the marriage. Can I represent one of them when they're getting divorced? The second was, Mike, I recently learned that my client testified falsely. What do I do now? I typed those into ChatGPT and I shared the answers in my blog. The answers were pretty good. They're basically tracked what I would have responded had it, or how I respond when asked those questions. Many other people have also written, hey, it can be good. So there's lots of information out there, I guess is my point about the benefits of using artificial intelligence and working it into your practice. Go find those, see if it's for you. Remember, however, there are also risks. And that's what I think this Avianca situation serves to sort of not reveal, but to reinforce. And by not reveal, I mean this. Nobody who does my job or anybody else out there who's encouraging lawyers to look into artificial intelligence and encouraging lawyers to integrate it into their practices has said that it's perfect. Me, I'm example number one. That blog post I did, yeah, it got the first two questions right. It got the third question I asked wrong. I had asked it, a common question I get is, hey, Mike, how much of my own money, if any, can I keep in the trust account? And in most states, the answer is none. In Vermont, we have an exception that says, well, you can't commingle. However, you can deposit your own funds into the trust account in an amount necessary to cover reasonably expected bank charges and fees. When I asked the question of ChatGPT, how much of a lawyer's own funds can the lawyer keep in trust in Vermont? It got the answer wrong. It cited to a rule that, well, the rule exists, but the rule doesn't say what ChatGPT said that it says. It said that the rule prohibits any amount of a lawyer's own funds. And it missed the exception. So there was a situation in which I warned, look, it's good, but be careful, it got this one wrong. Other people have issued similar warnings. Mark Palmer is a lawyer who's chief counsel to the Illinois Supreme Court's civility. Civility is the number two, then the word civility. And it's an organization that promotes civility, professionalism, and integrity within the legal profession. Mark did an article for Illinois Lawyer last month in which he discussed the legal ethics issues associated with artificial intelligence. One thing he pointed out was, hey, one of the risks, fabricated results. And when in pointing out those risks, Mark did something similar to what I'd done. He linked to tweets he'd posted in January. And in those tweets, he shared screenshots of, I think it was, questions he'd asked of an artificial intelligence tool. I can't remember which one, where he'd asked to do some legal research, and the legal research came back with cases that didn't exist. So I guess that's the point, right? Nobody has ever said it's perfect. All we've said is that it's a tool that has benefits and a tool that has risks. If you take anything from this Avianca decision, take this. One of the risks of using artificial intelligence to do legal research is I might get results that don't exist. I might get cases, statutes, whatever, that don't exist. So if I use this, if it's for me, if it makes sense for me, one thing I should remember to do in order to be competent, in order to carry out all the professional duties that I owe to my clients, to courts, and to opposing counsel, I should probably double check the work that comes back. That's the advice that I would give if somebody were to contact me with a question about, hey, Mike, does this mean that I can't use artificial intelligence in my practice? I'd say, no, it doesn't mean that. It just means that you are now on notice of one of the risks. There are steps you can take to mitigate against that risk. That's my response to the story. One sort of quick little postscript. The duty of competence includes understanding and abiding by court rules, local rules. There's actually another rule of professional conduct that requires lawyers to comply with court rules. In response to this, I believe it was in response to this, the timing suggests it was in response to this, a federal district court in Texas this week adopted a rule that requires lawyers, when they're submitting pleadings, motions, memos, to certify that if they did use artificial intelligence to do legal research, that a human actually site checked the result. Maybe many more courts are going to do that. I don't know, but keep abreast of your local court rules so that you understand your duties there. that's my takeaway on the Avianca story. Thanks to everybody who sent it. Thanks to everybody who's watching right now for getting through this, and hope you have a great day and a fantastic week.